proceed. And then the court says it's an application, so that maybe the revision application will be and file it. Otherwise, we cannot do two cases at the same time. We are going to seek that application because we don't need permission of the court. Thank you. And so we are requesting you that you court bears that in mind, because after all, we are going to review what has happened based on legality, propriety, and others. We believe, like I said, that common sense will require that we stop here. The High Court guides us. We come. We are not running away from here. We shall come. We are saying we want it to be done. We don't want to proceed, yet we are reviewing, so that we have discussion. That's the simple. And I'm sure Mr. Bill knows, because even in that case, we argued a lot, but eventually so we like it. So we asked him to see light earlier, so that we don't proceed. It normally takes long to see this thing.
These are very serious matters. First of all, I think my brother misunderstood the scope of application. It's not just a revision application. This is also an application for supervision. And as I kept saying that we failed here, it is also premised on Section 17 of the Educator Act. You all logically, it will serve no purpose for us to proceed to the High Court if you proceed with today's proceedings by the prayers of the Constitution. In other words, you will be indirectly telling us that you don't go to High Court, because there will be no purpose of going to High Court if you are going to hear committal proceeding. It is both illogical but also illegally and unconscionable to entertain committal proceedings whose net effect is to frustrate the mandatory bail of accused person. In law, it is called abuse of the process of law. If a magistrate conducts court in such a way that when the prosecution senses that the mandatory bail application has been triggered or is looming, to ensure that there is a committal so that the accused persons do not successfully apply for mandatory bail, that is an abuse of the legal process. It is important that we be mindful of the context of this military proceeding. The accused here were not arrested in Uganda, were abducted, tortured, illegally detained in the military detention for 4 days before they were arraigned before a kangaroo military tribunal. Can I proceed? Please, maybe, what can guide us?
That's okay, sir. Don't raise
Yes, I'm not raising issues. So, Article 43 of the Constitution, and in the context that I have said, forbids political persecution. What we are seeing here, the use of committal proceedings to stop mandatory bail is a stellar example of political persecution, which is prohibited in absolute terms by Article 43 of the 1995 Constitution. A prosecutor is precluded from using his office to initiate committal proceedings so as to forestall mandatory bail. This is my opinion.